Why might a defense attorney begin negotiating with you and your attorney as your case is getting closer and closer to trial? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. The doctor turns around and says, "Hey, why are you suing me? I did nothing wrong. And if I did something wrong, so did you, Mr. Patient. And by the way, I know I didn't do anything wrong, but you know what? If I did, whatever I did didn't cause or contribute to your injuries." And then they turn around and say, "You know what? If I did something wrong, whatever I did, your injuries are not really as bad as you claim them to be." So those are the typical defenses we see in these medical malpractice cases. And now the defense also says, "Hey, you know what? We are never going to negotiate with you. We are never going to settle this case. We'll see you at trial." Well, trial in New York means 2 or 3 years down the road after the litigation process is done. Okay? So now you're going to wait 2 or 3 years to actually get to trial. But something interesting happens as you are approaching trial, within a month or two before trial. The defense makes a call to your attorney and says, "Hey, listen, are you open to the possibility of trying to negotiate?" And now your attorney calls you and tells you, "Listen, the defense is interested in trying to talk." And you say, "Wait a second. At the very beginning of this case, didn't they tell us that they didn't want to negotiate with us at all? They said, let's go to a jury, let's have a trial on this issue?" And your attorney tells you, yes, that's exactly what they said, but now they've changed their mind. What would prompt the defense lawyer and the doctor whom you have sued to now want to go ahead and start negotiating right before trial? The answer is very interesting. The answer is really eye-opening. The answer is that the defense wants to minimize their risk and exposure. That's the only reason, from a strategic standpoint, why they would begin negotiating as they're getting closer to trial. And I'll tell you why that happens. As your case gets closer to trial, the defense is preparing their case for trial. And now, part of their preparation involves analyzing the risk. The defense does a whole analysis to determine if your case goes to jury verdict, and now the jury gives you a verdict in your favor, how much money are you actually going to get? And they come up with a range of what they believe a jury is actually going to do. And based upon that information, now they add some other variables in, such as the location, the venue where this is taking place, as well as what other similar cases have had for verdicts, as well as settlements. And now they begin to assess the risk of taking the case all the way to trial and letting a jury make the decision. Because here's the reality, and a lot of people don't share this with you. When you go to trial, whether it's a medical malpractice case, an accident case, or a wrongful death case, it doesn't matter how great your attorney is. It doesn't matter how great the facts of your case are. It doesn't matter whether the law is on your side or not on your side. When you go to a jury trial, the jury can do anything. And the problem is that the attorneys who are prosecuting the case, who are bringing the case on your behalf, your attorney, and the attorney who's representing the doctor in this case, or whether it's a hospital or somebody else who's being sued, those attorneys, they have no idea what a jury's going to do. It doesn't matter what great oratorical skills the attorney has. It doesn't matter how long the attorney has been in practice. All of those are variables that go into the equation of whether or not you may be successful, but there are never any guarantees when you go to a jury trial. Never. So you could have the best case in the world, and guess what? The jury could throw you out of court without a dime. You could have the worst case in the world, and the jury could tell you that you won and give you a significant amount of money as compensation for all of your injuries. The problem is, going to trial, you never know exactly what's going to happen. So let's go back to what I asked at the beginning of this video. What's going to prompt the defense lawyer and their insurance company to want to begin negotiating with you when they've told you at the very beginning of the case, "Hey, we're never negotiating"? What they want to do is try and minimize their risk. They want to minimize their exposure. When I say exposure, I don't mean public relations exposure. I mean the exposure to a large verdict. Because the fact is, even if the defense says they did nothing wrong, a jury can still come back and give you a verdict in your favor for a very, very substantial amount of money. And now everybody gets mired down into the appeals process, which could last 1 to 2 years. And there's so many different things, so many different outcomes that can happen on an appeal. So the reality is that the defense wants to try and explore the possibility of negotiating. It does not mean that you're going to reach an agreeable solution, but at least it opens the door so that now you can have an active dialogue. Now the attorneys can explore and begin arguing about liability, whether or not the doctor is legally responsible for your injuries, whether you, the patient, are partially responsible. Is there a link between the wrongdoing and your injury? And if so, how can we show that? Can we show that at trial? Are we confident enough? Do we have experts to go ahead and talk about that at trial? And then they talk about the value of your injuries. How badly injured are you? How permanent is this? How has your life been affected? What are you no longer able to do as a result of these particular injuries? And then they get down to the nitty-gritty, which is, what are your damages? Do you have economic damages, financial damages that have affected you and your family, as well as what we call non-economic damages, things like pain and suffering that you endured as a result of this doctor's carelessness? So why do I share this quick information with you? I share it with you just to give you an inside look at what really goes on in these cases here in New York. You know, I do understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit, but still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.